and there is a reference of a particular case between Ramsden versus Dyson. Let's start with dictation at the rate of 100 words per minute. Last 5 seconds. 4, 3, 2, 1. Start. The doctrine of equitable estopple was explained in the leading case of Ramsden versus Dyson. The plaintiff was tenant at will of the defendant. He erected a building on the defendant's land, alleging that the landlord's agent had promised to grant him a 60 years lease renewable at tenant's option. The plaintiff brought the suit for a declaration that he was entitled to a lease of that character. The court came to the conclusion that on facts the plaintiff did not believe that he had a higher right than of a tenant at will, and that it does not give rise to any legal obligation, and so the suit was dismissed, stating that the landlord could erect the tenant. But this decision explained the principle of equitable estopple as follows. The rule of law applicable to the case appears to me to be this: if a man, under a verbal agreement with a landlord for a certain interest in land, with the consent of landlord and upon the faith of such promise or expectation, with the knowledge of the landlord and without objection by him, lays out money upon the land, a court of equity will compel the landlord to give effect to such promise or expectation. In this case, equitable estopple was applied. In this case, the landlord granted a lease to the defendant for the purpose of erecting building for trade. The defendant then asked permission to erect a residence for his manager. The plaintiff replied that the lease was a permanent lease which gave the tenant the right to erect the buildings, but that the rent was liable to enhancement. Relying on the assurance, the defendant built the residence. The plaintiff then sought to evict the defendant, but Privy Council held that whatever the nature of the tenancy in its inception, the plaintiff was stopped from questioning its permanency. It was observed. Estopple prevents the plaintiff from evicting from there, holding the defendants whom the plaintiff induced by his representation and conduct to believe that they had a fixity of tenure, although not of rent, in the lands that had been leased to them. It gives effect to the representation that induced them to act as they did. Lala Beniram versus Kundan Lal. The Privy Council held that the owner of a land cannot sue for ejectment where he sees another person erecting buildings upon it, and knowing that such other person is under the mistaken belief that the land is his own property, purposely abstains from interference with a view of claiming the building where it is erected. From the above said cases, it is clear that the doctrine of equitable estopple or estopple by acquiescence assists bona fide holder under defective title. Acquiescence means abstaining from interfering while a violation of his legal rights is in progress. It operates by way of estopple against the true owner. Estopple by acquiescence occurs when the person having the better title knows facts which are unknown to the other persons, acting in violation of the right which those facts give, and does not inform them about it but lies by and lets them run into a trap stock.